Well, hello and welcome again to another episode in our Pastor's Legal Bootcamp video series. I'm your host, Attorney Joel Beck with Peach State Wills and Trust, the Beck Law Firm, LLC in Lawrenceville, Georgia. We are an estate planning and probate firm. And joining me here in the office today is my friend and colleague, Keith Miles. Keith is an elder law lawyer here in Gwinnett County and with offices in Duluth. He is also licensed to practice in North Carolina as well. And Keith is an experienced elder law lawyer, and we're going to talk about some possible situations that might come up with our audience of pastors and clergy who may be counseling folks from time to time, and that reveals an elder law issue. So our goal today with Keith is to kind of break down what some of these issues are, what things might be done to address that, and see what type of guidance he might have. Keith, welcome to the program. Thanks for being here.
Thank you, Joel. Thanks for having me.
Yeah, so you are an elder law lawyer, and I know what that means, but you know, I think a lot of folks don't. They don't really know how we as lawyers kind of break down into different specialties or practice areas, right? You're actually a certified elder law attorney. You carry that special designation, but for folks that don't really know what elder law is, what an elder law lawyer does, can you give a brief explanation of what that is?
Okay, sure. So elder law started with a focus on the population that you're serving. So obviously the older population, which we define as 65 or older, is our elderly, but we're really focused on people who are vulnerable. So they have issues of capacity, issues where they might need some attention for their health and some financial planning related specifically to that long-term care. Also, because of the vulnerability, we serve populations that are under 65, like special needs disabled population. So all those categories would fall under an elder law attorney. I am a certified elder law attorney, so it's a designation that the American Bar Association puts out through the National Elder Law Foundation. We focus on 12 different areas. I won't recount all of them, but just to kind of give an overview, it can range from wills down to resident rights. If someone goes into a facility, can you be ejected out for certain behaviors, or are there rights for being there? Elder abuse, not physical, more financial. If someone has a power of attorney and they come and they do some things with someone else's estate. Yeah. So we have a variety of things, certainly public benefits planning, Medicaid, Medicare. So all those things together would be what an elder lawyer would handle.
Okay, great. That's very helpful. So I think as I kind of thought through us sitting down and having a conversation for our audience today, I was scratching my head and thinking, okay, what really is a pastor or a clergy member or minister going to kind of experience that relates here? And I really realized there's really a lot that they might, as they're counseling folks in their congregation or in their ministry or organization. And one thing, the first thing that really kind of came to mind that I think they might experience somewhat rather often would be they have somebody that comes in and sees them, that the person has realized, hey, that my mom or my dad or maybe both, they can't care for themselves anymore. They can't manage their money and pay their bills and look after their property. Maybe they can't take care of and, direct and manage their health care. And unfortunately, in many situations, there's been zero planning to address any of this, right? I know you've seen that. So in a situation like that, Keith, what are the first few things that maybe come to your mind that they would need to address?
Well, that's such a common situation for not only elder lawyers or estate planning attorneys. We are approached many times by someone else. So the first thing we need to do is identify who the client is and explain that to the person who's coming to our office, that the older person, whether it's a parent, friend, or whoever they're representing, they may have power of attorney already, which sometimes they do. Sometimes they're seeking power of attorney. We have to let them know who the client is, and that will guide us ethically of how we proceed. So the first step is identifying who the client is. Then we have to go through the representation and make sure we are focused on the needs and best interest of that elderly person. Often that might be in conflict with the person who's coming to see us, right? Because the person who is elderly may have, for example, a desire to stay home for the rest of their life. I want to get care at home. That might exhaust the finances that they have, which they intended to leave to the children. The children are the ones coming in, saying we want to plan to save those funds. But if the client who says, I want to use those funds until I need to, pass on, that might involve something that the children aren't happy with because they want to save money that the other person wants to spend, the client. So those issues for anyone who's dealing with someone coming to them, we would say, number one, have the client come to us, the older person come directly, if possible. If they cannot, then we are switching from a planning case to more of a guardianship conservatorship case where we need the court to come in and potentially award someone the right to make decisions for that person. And that's something that I would say you want to spot issues of difference of behavior. If you see maybe what we call undue influence, where someone is coming and you see that they're talking about things that other people want. So these kind of issues with the elderly are really the capacity issues that we're looking at.
If it gets to a point where somebody has recognized that mom or dad or both, they've really kind of lost capacity, they can't really do anything to take care of themselves effectively anymore with respect to their health care, their money, property. You talked about guardianship and conservatorship. So that's where that might fit in here, right?
Correct.
And can you just tell our audience an overview, what is a guardianship
Sure.
and conservatorship, here in Georgia? What does that really mean?
Absolutely. So we try, if someone comes early enough, or if they come late and the person still has capacity, to give what's called a power of attorney. And that's a document that will say, I give this person powers to make decisions for me, particularly involving finances. And if that is done correctly, that person will have the authority to go ahead and do the things for the individual. What happens often in our cases, people wait too long, and by the time they come, the person who's the client, the elderly person, cannot actually give the power of attorney. And that's what happens. We have people come and say, I'm seeking a power of attorney. No, you have to actually be given a power of attorney. So if that person is not at the point where they can give that power anymore, now we are looking at a situation where we might need to go to a court, the local court in the county where the person lives, and ask the court to award the right to make decisions. Guardianship is over the person, taking care of their health, where they live, decisions about their lifestyle, or conservatorship is over the financial piece. You might be awarded both, or they might give you one role or the other. Mm-hmm. But that is going to be determined by the court. So that sometimes also happens if someone has a power of attorney in place, but that power of attorney is not sufficient. Sometimes people trying to save money will do things on their own, mm-hmm. and those power of attorneys that they pull off the internet or wherever else they got it may not have sufficient powers to do the things that they need to do. Right. So even though they have a power of attorney form, the lack of the powers that it needs requires that we go to court to do that.
And so the probate court here in Georgia is the court that deals with guardianship and conservatorship, right. And that would be an avenue where if mom or dad have not done any planning whatsoever, or their planning is defective in some way, and they can't take care of themselves, often kind of as a last resort, the adult child or somebody else is going to have to go seek that guardianship or conservatorship, right?
Right. And it's sorry to cut you off. The issue with that process also, the court might not award the rights to the guardianship to the people who seek it.
Sure.
So if you have a contested situation where one sibling is saying I should do it and the other sibling is saying I should do it, the court might very well say neither one of you is going to do it and award a public guardian, right? So there's a lot of things that go into that process. So the earlier someone can get into the office to avoid having that whole scenario happen, the better.
Yeah. So let's talk about a situation where mom or dad might have capacity. Maybe they're starting to show some signs of impairment. Maybe there's a diagnosis of some memory impairment concerns, Alzheimer's, some other memory impairment issue, but they still have regular moments where, they know who they are, they know what they're doing, right? Mm-hmm. And so we would say as lawyers that they've got capacity at those times to act. Before things progress farther where they lose capacity, what are some basic things then that the family ought to think about to make sure that mom or dad have their legal ducks in a row?
Ooh, that's a broad question. Well, we definitely, as an attorney, we're trying to get a full picture. Okay, so whether that's family assets, so that lucidity that might be temporary, we need to judge in that period of time, are we getting the full fact scenario? So the more you can document your assets and keep kind of track of everything and present it to the attorney, and so that we can see, okay, we're getting 100% of the picture, and then we have to work from that to say, okay, let's know the family, get from the person what their desire is, because just because there are 3 children does not mean I want to treat all 3 of them equally. Okay? Mm-hmm. There are a lot of assumptions that happen by people that approach us about what mom or dad would want to happen, which is sometimes different than what mom or dad actually wants to happen.
Right.
So the more that if someone can write it down, or I'll even take a videotape if they realize that there are moments, but we need to really not assume is really the fundamental thing, because it's very easy to assume that someone wants to take care of a spouse, someone wants to take care of children, and that may very well, based on their history, not be what that person wants to do. Okay. So we really want to get to the person's ideal plan to the exclusion of what everyone around them wants. And that's often the difficult part of it, because the person who's the most able to communicate may be in conflict with the person who's really the client.
Okay. In thinking about those situations where somebody still has the capacity to plan, I imagine you'd probably agree with me that probably at a minimum, the family wants to make sure that before things progress and that person deteriorates further, we want to make sure that they've got in place, a good power of attorney to deal with finances, a good healthcare directive to deal with medical care, and then a good will or a trust, right, to dispose of assets. And I think, that's really, I think, you and I have talked before. I think we'd agree that that's probably the foundation of a good estate plan for anybody in Georgia, whether they're 18, 30, 40, 60, 80, 90, right? Those are the 3 documents that probably at a minimum people need. But I know we get into some situations where I think folks are maybe kind of considering how to care for their aging parents. Mm-hmm. And the financial aspect of that can be a significant concern, right? Because when you look at the cost of skilled nursing care, when you look at the cost of assisted living or what have you, that's just skyrocketed, right? And there's such a need for that. Are there steps that can be taken to help provide for the parents' care while also working to protect some of their assets? Talk to us about that. Right. What are some things to think about there? And when's a good time to start thinking about that? Do we start thinking about that early on or only at the point of crisis? Mm-hmm. I ask a lot of questions there. See what you can do to unpack that.
No, I see where you're going, and I think I can try to get us there. The number one thing that the elder lawyer has to do is start with the basic estate planning documents, the estate planning process, and then modify it based on the long-term care needs. Okay. So if someone has a will in place, that plan is based on I pass away essentially healthy or quickly enough that I don't drain my assets. And then the will function to do whatever, go through the probate court. A trust is similar, except you're trying to avoid the probate court, but again, still the same kind of desire that I'm going to pass away fairly healthy or fairly quickly. If we have a situation where there's an extended need for long-term care, where we might drain expenses, someone needs to start looking at, can we do this for a certain period of time? And that will depend on that person's assets. We don't have the same answer for someone with $300,000 we would have for $3 million, right? Okay. So the first thing we're going to do is, okay, if we need long-term care, can we go long enough that we can keep those base documents in place? If so, great. If not, Now we might need to change what we did before. We might have a revocable trust. Now, a revocable trust works very well in certain situations. Once you need care and we are now looking at potentially draining our finances, we might look forward and say, at a certain point in time, we might need to use a government benefit called Medicaid. Okay? Many people are familiar with Medicare from working. They get to 65. It's essentially health insurance. So if they go into the hospital, it will cover the hospital costs, doctor costs. But if you need custodial care, what we call long-term care, care at home, getting out of bed, toileting, things like that, that's not going to be covered by Medicare. We need Medicaid. Medicaid is a means-tested benefit. You cannot get it if you have too many assets and too much income. And they have a formula on each side of what is included. So for assets, they include all assets in a revocable trust. So if I have a plan that's designed for passing things along and avoiding probate, it might very well hurt me in the Medicaid planning process. So we might need to take that revocable trust, undo it, and do what's called an irrevocable trust, a trust where we move assets into the trust. It is no longer ours anymore. But to do that, we have to have a period of 5 years. Medicaid, understandably, because we know that it is a limit on assets, understands that people will presumptively think they can move assets out of their name and then put their application in and apply once they have done so.
So I can get the government to pay for my nursing home care if I just go ahead now and give all the money away to my kids.
Correct.
But you're saying, that don't do that. Right. That's not going to work. There's this waiting period.
Right.
Okay.
So there's we call it a look back from the day that you put your application in. The government says we are going to look back 5 years to the day and see if you have given assets away. If you have, we will total them up and assess a penalty where you will not qualify. So when someone comes to us, we have to have that potential for waiting 5 years in mind. So the first question is, what is your health? I could have a 70-year-old that's very healthy and figures I have longevity in my family, which is what we hear often, and they figure they don't need health care for 10 years. We might start that process. Someone else might be 50-something, but they notice they're already experiencing some issues. We will start then. As a general matter, I talk to it about everyone 50 and over, just because our definition of elderly is 65. So we kind of just start having that conversation. Even if we wind up doing a revocable trust at that point, we will let them know you might need to come back if you start to think that this might change.
So it sounds like if paying for care is a concern, starting much sooner rather than at the point of crisis is definitely the way to go to have more options.
Absolutely.
Right. So it's not something to put off.
It's not something to put off, and it's not something to assume won't happen to you. And that's often the issue. We're talking to somebody, especially in the estate planning field, people think that this is something that's very remote possibility for them in general. It's something down the road. So with healthcare, someone feels, I feel great today. I don't think that I'll have this issue until I'm 70-something or 80. And they may just not be receptive to these. So I think we have to kind of force that conversation on them a little bit. You can only do so much. But I think you have to bring it up at least at that point in time and then inform them there may be something else you need to think about in this process beyond just passing something along after you pass away.
Yeah. So I think, Keith, in situations like we've talked about today and others relating to elder law, tell us, why is it a good idea for people to consult with a lawyer who really focuses their practice on elder law issues as opposed to, say, a generalist lawyer that tries to handle a little bit of everything?
Yes. Now, that's an excellent question. This area, just like estate planning, is very state specific. So that's the first issue. It's a mix of federal law and state law. So those rules change periodically. It's not information that's very easy to take off the internet or some reading on your own and get it right. So I think that this is an area that someone has to really seek someone who's watching these rules, understand what the terms may mean and not mean, the subtleties of things. But it's definitely an area that also people don't understand. It's not a transferable benefit. So if I am in Georgia and I want to move to North Carolina, I would have to reapply for Medicaid. There's different rules. I'm a member of both bars. They are pretty much polar opposite rules. So you can have a lot of things that you qualify for in Georgia that you do not qualify for in North Carolina. It could be devastating. So sometimes people come and they're debating where they should move. We can do that analysis for them. If you move, this will be an issue. So if you have different children you might relocate with, we can do those analysis between locations and say this is probably the better option for you. So I think you need to seek someone who has that kind of knowledge to track those differences.
Yeah, I mean, it definitely is, and I know this from our estate planning and probate practice. Elder law takes the complexity to a whole new level. And when folks are wrestling with elder law issues, it's really a good idea for them to consult with a certified elder law attorney like you. This has been great information. I think it's going to be helpful to our audience. But if somebody wanted to learn more about you, your law practice, where can they find you?
Internet website is www.estateplanesq.com, www.estateplanesq.com, or if you want to use the phone, 855-535-3375, 855-535-3375.
Well, Keith, thanks so much for being here, sharing some of your expertise about elder law issues with our audience. I think they're going to find it very helpful in situations where maybe these pastors, these ministers are encountering folks who are dealing with issues with respect to aging parents and other special needs populations that relate to what we've talked about today. So we appreciate you being here, checking out this other episode of the Pastor's Legal Bootcamp. Be sure to check out our other videos and then come back to our blog here or our YouTube channel to find more videos as they're added in the future. I'm your host, Joel Beck. Thanks so much for joining us. Bye.